Now, this past week, the Registrar of Labour Relations called on employers and labour unions to prepare for secret ballot legislation by changing their constitutions. And they're running out of time as they were given 180 days starting from January. So they need to be compliant by the end of this month. To give us a sense of what all of this means, I'm now joined by labour law expert Osborne Molatudi. Thanks so much for joining us. Welcome to the programme.
Thank you, Peter. Good to be back.
All right, so the Registrar of Labour Relations sending out this letter and this call to employers and labour unions, and that's because they're running out of time. Remind us again of what this legislation change is.
I think firstly, what we need to clarify is that the amendment that came about relating to secret balloting not only applies to trade unions, but it also applies to employer organization. So in other words, as much as trade unions are required to conduct secret balloting before they can call a strike, employer organizations are similarly expected to do the same.
Workplace forums peculiar to a company.
Yes, so employer organizations, before they can lock out striking employees, they are also expected to conduct secret balloting. So the amendment applies to both trade unions and employer organizations.
Right.
But the history of it is that, and this is another misconception that needs to be cleared out, balloting has always been there. It's just that it was never applied for because it was not secret, and so it was never utilized. So the lawmakers then said, in order to test whether a particular strike or lockout has the support of the majority of members, let's amend the Labour Relations Act and put in place a requirement for secret balloting, which is then expected of trade unions and employer organizations to do so through their constitution, by amending their constitution.
Okay. So everybody has to be compliant 180 days from the 1st of January. What happens if you're not compliant? I mean, can you not change your constitution but do secret balloting?
The provision on secret balloting is peremptory. So the Registrar of the Labour Relations as well as the lawmakers are not asking for permission from trade unions or employer organizations. They must comply with that. Otherwise, they risk having their membership registration being cancelled or being deregistered. And the worst is when they can even be placed under administration for non-compliant with the binding provisions of the Labour Relations Amendment Act. So there are serious consequences. So we expect that trade unions and employer organizations have started the process long time ago. They've been given 180 days. Coincidentally, I mean, it expires almost at the end of this month or first week of June, if one were to exclude public holidays and Saturdays and so they have to comply. So
the registrar can check the constitutions of these companies to make sure that they've been amended, and I suppose it has to lay out how a secret ballot will be done under work circumstances, etc.
Indeed. They have also, the Department of Labour has issued the guidelines late last year in December. Most trade unions and employer organizations, they should be aware of those guidelines. It's the same as the national election. There has to be a date, time and place, method of voting, the keeping of the record of voting. And those are the things that the registrar will check. But mainly, the registrar will simply check whether either a trade union or an employer organization has actually amended their constitution to make provision for secret balloting. I think this is the most important thing. Balloting has always been there. What is required of them is to go back, amend the constitution in order to include secret balloting of their members, so that whether or not a strike or a lockout has the majority of support, it can be done so without fear by any of those members.
Okay, so then what happens when a strike does happen and it wasn't done by secret balloting?
This is an interesting question because one was inclined to say, trade unions, prior to the expiry of 180 days, they can actually call on a strike without doing a secret balloting. But the bad news for them, or even for employer organizations, is that there has been a latest judgment in Durban, which simply ruled that the transitional provisions on secret balloting are actually binding from now. So there's no time that is being given in terms of the trade unions being compliant or not. There was an argument by NUMSA, for instance. They said, no, the transitional provision, the requirement to do secret balloting infringes on the members' constitutional right to strike. And the judge simply ruled that no, secret balloting has always been there, so there's no infringement. It's only the fact that you are now required to go change your constitution.
So what you're saying is, from January the 1st this year, already secret balloting was law, and that the provisions, that this transitional arrangement was just to get the what do they call these? There's constitutions in line.
Yes, just to give them time to comply.
But otherwise, any strike has got to be called by secret balloting.
Any strike to be called after that judgment will have to be preceded by secret balloting. So if a union calls on a strike or an employer organization intends to lock out strike employees, they will have to conduct secret balloting, failing which that strike or lockout can be interdicted according to this judgment. It's a very interesting judgment, and my view is that it has opened avenues for employers and also the trade unions to actually make use of it to interdict a strike or a lockout that is that does not have secret balloting beforehand. So it's going to be interesting going forward. But in any event, this issue will no longer be an issue for debate because the 180 days will expire. And surely unions will know that they can't call a strike before they even conduct secret balloting of their members. The same would apply to employer organization. They cannot lock out the strike employees before they can conduct secret balloting.
What happens in a hypothetical situation where workers all agree together, and it's not in secret, that listen, we're going to down tools, and there's a clear majority, everyone there just says no, we're not going to do this? Do they still have to go through the process, even though they might have said openly that
we support the strike? Employers will take advantage of that. They will say the strike is not in compliance with the law. The law requires you to conduct secret balloting. Because even if there's a public show of hands, you never know. People secretly may have certain thoughts about the effect of a strike. It's no work, no pay. So basically secret balloting is just to give those members who may feel reluctant to show disapproval of an intended strike or even a lockout by any members of an employer organization. So either way, whether it's supported publicly, etc., secret balloting is a must. It has to be conducted.
Is there a downside to this piece of legislation at all?
I think the only downside is the constitutional implications, because I think as much as unions put up the argument that this requirement for secret balloting infringes on our members' right to strike, but at the same time, there's pressure on the lawmakers, the government in particular, to try and do something about strike that go for a long time, that are accompanied by violence, intimidation, etc. So that's why lawmakers went back to the drawing board and say, let's put something in place and see whether this will minimize proliferation of strike. Because sometimes you can have a few number of dominant players in a larger group who influence the entire workforce or the entire employer organization, when in fact those members, silent members, actually do not support the intended action, be it a strike or a lockout. So that's the only downside. There's going to be a bit of litigation, or even a lot of litigation, around the constitutional implication of this requirement.
Helps clarify the law, actually, so maybe not a bad thing.
Indeed, but as matters stand, secret balloting is peremptory. Both trade unions and employer organizations have to comply once the 180 days expires. If they do not have their constitution amended, they run the risk of being penalized in the form of deregistration, cancellation, or at the worst, being placed under administration.
Okay, labour law expert Osborne Molatudi, thanks very much indeed. It was a pleasure talking to you.
My pleasure as well.